This program was made possible with the generous support of the Magnolia of Millbrae. The Magnolia of Millbrae is a senior living community that provides a variety of services and amenities to its residents. For more information, call 650-697-7000 or visit their website at www.themagnolia.com. MCTV thanks them for their support.
Welcome to Wellness Update. My name is Sherry Plambeck. I'm the Director of Sales and Marketing at the Magnolia of Millbrae. We are a senior retirement community. We offer independent living and assisted living, and we're located in the beautiful city of Millbrae. Today, our topic is, what is estate planning? And our guest today is Steven Wohl, and Steven Wohl is a practicing San Mateo County attorney for over 35 years. And has wonderful experience working with families and individuals. Steve, welcome.
Thank you, Sherry. It's really a pleasure to be here. Thank you for inviting me.
Well, we're delighted you're here. Steve, tell me, what is estate planning?
Estate planning is an opportunity for individuals and families to make clear choices as to how they wish their lives to be conducted if they're not able to manage their own affairs, or at the time of their passing, how they wish their assets to be handled post-death. So I always define estate planning because the issues of incapacity and death are not very appealing, and certainly no one really wants to dwell on it or think about it, but some things are inevitable, some things are not. But I always try to color it in a way that people take advantage of the fact that it is an opportunity and not a subject to be avoided.
Well, this segment today is really going to be dedicated to incapacity. So explain to me exactly what is incapacity for a person?
Incapacity is basically a legal term where an individual is unable to competently manage his or her own affairs, whether they be financial or healthcare decisions.
So we as individuals do have an opportunity to make choices?
Yes, obviously, if you're able to handle your own affairs, you will conduct your business as you normally do day by day. But should there be a circumstance, whether it be due to illness or age or an accident, where you're not mentally or physically able to take care of your own business, or make your own health care, you are able to select one or more individuals to stand in your shoes and make those decisions for you if you're not able to do so yourself.
Let me ask you this. If I do want to make a choice, what documents can I create to do that with?
There are two basic types of documents to handle the incapacity planning. I'll start with the set of documents that pertain to property, business, and money. That document is called a durable power of attorney, and it is a written instrument that sets forth who you wish to stand in your shoes if you're not able to take care of your own financial, business, or money concerns.
Let me ask you this, Steve. Is there an age requirement for having that document completed? Or should, say, a younger person, maybe age 25, have that as well as somebody that's maybe 80, 85?
Any adult is able to create a durable power of attorney. And again, none of us have a crystal ball. We do not know if and when we are ever not going to have our capacity. So I have many clients who are young, in their 20s, who create durable powers of attorney because they acknowledge the fact that it is a possibility that there may be an illness or an accident which would render you unable to handle your own affairs. So there's no minimum age other than being an adult in the state of California, which is age 18. And there's obviously no upper limit of age to create these documents, so long as you have the legal capacity to do so.
Let's talk about a 21st century family. Things have changed.
Things have changed in that in the old days, you would always assume that the men were out working, taking care of all the business, and they were really the only ones that needed to sign documents. But these days, I find more and more women are very much in the workplace as CEOs, CFOs, or often the primary breadwinners in a family. And especially these days where both spouses are involved in managing financial affairs, it's very important that both are able to sign their names or take care of affairs, and it's not just dependent on one spouse to do everything.
Let's say we're talking about a couple, they're purchasing a home, they have 3 children, and let's say the mother is the CFO of a Fortune 50 firm. So she's traveling overseas. And perhaps, even although we have so much technology nowadays, perhaps she cannot get a document that needs to be signed. Can the spouse sign that document?
And this isn't, yes, with the right sort of durable power of attorney. We always talk about durable power of attorneys in an incapacity setting, but there's also a very large convenience factor, because if you create a general durable power of attorney that says at the time you sign, you are empowering someone else to stand in your shoes, a spouse can say, well, I know I'm traveling, I want my spouse to be able to sign for me, and so I'm going to create a durable power of attorney that allows my spouse to sign for me as if he or she was me. And that is a very valuable and convenient tool to have. Admittedly, though, most times durable power of attorneys are viewed for incapacity, where someone may be just not able to make his or her own decisions or may not be able to sign his or her name. But there are many circumstances where a power of attorney can be very valuable just for convenience. Seniors often will create a power of attorney, even though fully competent, where they may want a child or a spouse to take care of business because it's not convenient to go to the bank, or a spouse is just not feeling well enough or doesn't want to take the time to do it and would rather entrust those duties to somebody who that person feels is beyond a shadow of a doubt completely trustworthy.
So people really have the power to make the choice.
It's a very special opportunity for you to select who you would want to take care of your business, either if you're not able to do so yourself due to illness, or if you're traveling and you want somebody to be able to take care of your business for you while you're absent. You make the choice. You pick. It isn't up to someone else to decide. You actually have the right and the power to make whatever specific choice you wish to make.
Now, I'm sure you're very aware, especially being an attorney, sometimes families, as loving as they can be, they don't all get along. And sometimes there's somebody in the family that's perhaps a banker, maybe there's somebody that is on the medical side of things for a profession. But I think it's very important for people to be considering whom this person is going to be that they're giving this power of attorney to. Am I correct in that?
That's absolutely correct. It's a very powerful document. And I always caution my clients, you do not give these powers lightly. My standards are, if you're going to pick one or more people, they need to have the highest level of integrity, trustworthiness, and really that you're not going to lose any sleep knowing that the person you've picked is going to be in a position to access your bank accounts, to transfer real estate, to sign loan papers, to take care of your affairs as if he or she were you. So you have to be very, very cautious. And in terms of the possibility of problems within a family, there are times where siblings can get into a little bit of an arm wrestle over the control of a parent, even though they both may well love the parent equally and only want the best for the parent. There's always that factor, is there going to be sibling rivalry or resentment within a family in choosing one over another. But you have to balance all these factors out. The most important thing for someone to consider is, who is best suited? Who do I trust? Who do I know beyond a shadow of a doubt will take care of my business as if I were doing it myself?
And sometimes, even if this is a family that has, say, 3 or 4 siblings, sometimes it's really better to have a friend.
I've had clients select people outside of their immediate family for that very reason. Sometimes they don't feel comfortable with their children being involved. Sometimes they don't want to create an atmosphere of sibling rivalry where they may pick a sibling, their own sibling, or they may pick a very close friend. It's a case by case. I really want to make sure that people understand that each family is unique, that I never assume that the Smith family is going to be just like the Jones family.
No, genetics play a big factor in things, and thank goodness we all have our own DNA.
And also life circumstances. whatever your life experiences have been will color the way you view the world. And I think I'd like to just break the power of attorney discussion into a couple of subparts. There is a power of attorney, but there are two different types of durable power of attorneys that are available to an individual. One is what's called a general durable power of attorney, which I referenced earlier, which is when a person signs it, it's in effect right then and there. So that's where the convenience factor can be in play. Immediately. So if I give my wife a general power of attorney, and let's say I'm somewhere else, she can take care of the business even though I'm fully competent. For many people, that's fine. For some people, though, they really aren't comfortable having somebody else with the same powers unless it's absolutely necessary. In other words, someone may not want that power of attorney to be in effect unless, in fact, he or she is truly incapacitated. So it's basically can be what's called an emergency document, which is a springing durable power of attorney. And by springing, it means it only springs into action and into effect if a physician has certified that the principal is in fact incapacitated and not able to make his or her own legal decisions. And that's another type of a power of attorney that some individuals choose because they're uncomfortable with the idea that this document is out there giving someone else the power when they're still able to do their own business. It's a case-by-case approach. It just really depends on how the individual feels about who they're picking and whether they want that document just to be there as an emergency. And it's really a very individual choice. And there's no right or wrong on this.
So if you're having a springing durable power of attorney, that would have to go through an attorney to do
Generally, power of attorneys are best created with the assistance of an attorney. A springing power of attorney takes a little more of draftsmanship just to make sure the right terms and the right conditions are recited, consistent with what the client wants in terms of whether is it one doctor that has to say that he or she is incapacitated, or does the person want two doctors? I've drafted them both ways. It's a very individual choice to be made because it's really there's no one way just to do this. And I have clients who say, if one doctor says I'm incapacitated, that's fine. And others say, I want two. I want there to be a consensus from two doctors. Because sometimes situations happen where a child will take the parent to the doctor.
How true that is.
And the doctor can be talked into it. Two doctors are less likely to be talked into the same thing. Even though I have a lot of respect for the medical profession, having worked with doctors extensively, they don't give out certificates of incapacity lightly. They really want to be absolutely convinced that someone is incapacitated before they put their name on the dotted line.
I think it's very important for people to really know that there is an alternative there by that springing durable power of attorney.
It is. It's very important. Sometimes,
because somebody could have a mild cognitive issue and somebody in the family could automatically want a physician to state a certain issue for a primary diagnosis, which in reality might just be a mild cognitive impairment, but if you have a second backup physician, your chances are much better on getting the true diagnosis.
That is correct. And so when I'm meeting with clients, I discuss this with them in terms of giving the full range of options. And the good thing about estate planning is that it's crafted individually. It's not one size fits all. And when I say it's an opportunity for your voice to be heard, not just in the documents we're talking about today, but just any documents that have to do with incapacity or death. Your voice can ring loud and clear and be what rules the day, instead of having some other person making decisions that you may not make yourself. That's why I try to really emphasize the opportunity aspect of it. I always look at, we don't have that many chances in life to make choices. There's certain things we are required to do, which is fine. But there are also some opportunities to make choices that are very fundamental, and I say, if you have the opportunity, why not take advantage of it?
Now, what about the issue of health? How does that play into this?
Well, that's
with
another.
Advanced healthcare directives.
Advanced healthcare directives are the tool used to create preferences in writing that are binding, that is, say, who you would want to take care of your healthcare decisions if you were not able to make them yourself. And the healthcare is a far more emotionally charged set of issues. It's not uncommon, for example, for a parent to be very ill, and there's the son and daughter both at the hospital, and there's nothing in writing saying who's in charge, and the son and the daughter both love their parent. It's not a matter of who's not loving the parent, but there could be very different viewpoints. And probably the most dramatic illustration was many years ago. There was a young woman in Florida named Terry Schiavo who became chronically, grossly ill in a vegetative state in her early 30s. She had not done any planning at all. And so her husband got into a tremendous legal battle with her parents as to how her health care was to be managed in the absence of Terry Schiavo's ability to manage it herself. It went on for many years. It involved court proceedings, and hundreds of thousands of dollars were spent. Had Terry Schiavo created an advanced health care directive, she would have been able to say, I want my husband to be in charge, I want my parents to be in charge, or maybe she would have picked her best friend to be in charge. We'll never know because she never took advantage of the opportunity of making her choices known. So in California, we have the opportunity to create what's called an advanced health care directive, which says that if I'm not able to make my own medical decisions, this is one or more people who I wish to stand in my shoes and make those decisions for me, to be able to speak to my doctors, to be able to express my voice. Since I'm not able to do it myself, I'm delegating that right and duty to the people I've picked, not someone else's choice, but my choice. And this is who I want to speak to the doctors and to make decisions that affect my medical care and treatment.
You know, I think it's so interesting. People and families, they talk nowadays about having this much money for this, for that, college educations, etc. But I think something as important as your own health and the management of really your property, you don't realize how important it really is to have these documents put in place. And I guess it's just really never too early.
It's never too early, and it's so fundamental. It's interesting in my practice, when I get a potential estate planning client come to see me for the first time, most of the times they are there to talk to me about what happens when they pass away. But I always start with the incapacity. Again, I say, if you know if you're going to die before you become incapacitated, I'd like to borrow your crystal ball, because I don't have that crystal ball. We just don't know.
None of us do.
So the incapacity planning is a very crucial part of the estate planning. And the bottom line is we are living longer as a population. And there is increasing amounts of dementia, early dementia, Alzheimer's that are occurring now. And so why not take advantage of the opportunity to say, this is who's going to be in charge of my medical if I can't take care of my own decisions myself. And another beautiful thing about the healthcare directive, it allows you also to make directions about what after death, whether it's acceptable to have a donation of organs and tissue, whether you wish to authorize an autopsy, whether you wish to make specific provisions for the disposition of your remains after death. It's all in one document. And it's a document that's going to be there in play at the time of your passing, because if you're getting any medical care at all, that document is going to be in the hands of the primary physician, the family's going to know about it, and it's all right there in writing. Because if you don't put this in writing, you're leaving it to your loved ones to guess.
What about on the California driver's license? You can have that little pink dot on there that says donate your organs. Is that valid if you don't have an advanced health care directive?
It is valid in terms of providing guidance, but still the driver's license little pink dot doesn't say who's in charge. And so somebody has to authorize the donation. And even though the driver's license shows a clear preference of that person for a donation, who is going to authorize it? And it may be that the person who ends up being in charge doesn't believe in organ donation.
So it'll never happen.
It may never happen.
And legally, nobody's bound to make sure that does happen.
It gets very difficult to enforce that, because if you have to go through the court system, it's going to take quite a long time. So the key is to pick a healthcare agent that you know is going to honor your wishes. And I encourage my clients to have discussions with potential agents to make sure that these individuals were on the same page.
Are there different types of advanced healthcare directives?
It's not so much of the different types. There are different options within the document. The integrity of the document is uniform. There are different versions of the document. There is what's called a statutory form, which is mandated by the California Probate Code, and that is basically a pre-printed form that is distributed often by HMOs. The California Medical Association has it available. You may be able to find it online with California-oriented legal resources. It's basically a fill-in-the-blanks form. It needs to be witnessed by two people or notarized. That is a perfectly acceptable way of creating an advanced healthcare directive. But it does not have as much flexibility as what I call a proprietary form, which is one that is drafted by an attorney, which has a lot more flexibility. And some clients choose, because they want to have certain nuances more clearly expressed, they prefer to have an attorney drafted advanced healthcare directive. That being said, the statutory form works fine. I always tell my clients that it is out there, available if they wish to choose to do their own advanced healthcare directive. That is the one part of the estate plan that actually individuals can do fairly easily if they're comfortable with using the pre-printed form.
And there are resources out there for people to go to, because I know sometimes, the internet, you can Google things and you can find out a lot of information, but the state of California, I would assume each state is very different in what is required by law and what is acceptable.
That is correct. There are sites out there that try to satisfy all the states, and you may end up with a form that's really intended for Florida, not for California. So you have to make sure that it specifically recites the fact that it is a California form. But certainly, one can always contact the California Medical Association or check with your HMO or your healthcare provider.
So there are many advocates out there that can assist people. Now, let's talk about the pulsed form, which has become so popular, that hot pink form. Explain to me a little bit about that emergency form and how it's really used.
This form is meant to be supplemental to the Advanced Healthcare Directive. It is meant for situations where if someone in his or her residence or place of work has a dramatic, sudden, traumatic illness or injury. It stands for Physician's Orders for Life-Sustaining Treatment. POLST is the acronym for it. And it is generally a pink form because it needs to be found. Mm-hmm. Most people don't have hot pink paper sitting around in their apartments or houses, but it is a form that must be completed with the assistance of your primary physician. A lawyer cannot create a POLST form. It needs to be created in concert with your physician, and you provide direction in that form for emergency personnel that arrive at your home or place of work. If you're in a coma or you code blue, you're whether to resuscitate and to what extent you want treatment on the scene. It is not meant for long-term care issues. It's meant really just for 911 personnel to arrive and to know what to do, whether to resuscitate or not to resuscitate. Because in the absence of that, they will resuscitate. And it can be very extreme what they do physically to bring you back.
Especially if somebody is older.
Right. And so what I recommend to my clients, especially, it doesn't have to be just seniors, but especially for seniors who live alone, is to consult with your physician, talk to your doctor about a POLST form, have the doctor assist you with the completion of a POLST form, bring it home, put it either on the outside of your refrigerator or wrap it up in a clear plastic container and put it inside your refrigerator. 911 personnel are trained to look first at refrigerator outside and inside for that pulse. And that pulse will instruct the 911 personnel what to do and what not to do.
What happens if a person becomes incapacitated instantly? Say 40-year-old male has a stroke, has a hemorrhagic stroke, totally incapacitated, has no advanced health care directive. What happens to that individual and, say, his family?
And I'm assuming likely no durable power of attorney either.
Nothing.
So that's
totally incapacitated.
What this means is that that individual has not provided any guidance or any legal documents that indicate who's in charge and what powers that person may or may not have.
This person thought he was going to live forever and still young, and why waste my time doing that, or why go to the expense of doing that.
And so what that means is that somebody has to step forward to take charge, because that man is still going to get bills in the mail. Medical decisions are going to have to be made. So somebody needs to become in charge of this ill person's affairs. And in the absence of formal legal documents, it will be necessary for someone to petition the court to be appointed as what's called the conservator of that person. And what conservatorships are court proceedings, and generally it's in the county in which the ill person resides. It can also be someone who just becomes elderly and incapacitated too, and hasn't done this. But let's stick with the example of the 40-year-old person who just didn't do any planning at all. Somebody has to step forward, petition the court to be appointed as that ill person's conservator. And there's two parts of the conservatorship. There's the conservatorship of the estate, which means taking care of money, property, and also conservatorship of the person, which is determining where the ill person is going to live and what the person's medical care is going to look like. And anytime you involve the court, even though we have wonderful judges and a wonderful court system, it's very cumbersome, it's very time-consuming, and it's very, very expensive. And so it can really create a lot of inconveniences for whoever is going to step forward and take charge of that ill person's affairs. The other part is it may not be the person that ill man would have picked. It could be the last person on earth that he would have picked. Because if you're silent as to what your preferences are, who knows who really that man would have wanted? And it can be well-intended people who would not have been that person's choice.
So this is really one time in life where you do have an opportunity to have a voice, and you really do need to you need to speak up. But what happens, say a couple is married, they get divorced. Now, all of a sudden, maybe there's a new spouse involved. Well, that other spouse may now wish that loved one to not have things done the way that loved one wanted. So is this something that should be reviewed on a yearly basis?
Yes, estate planning, irrespective of your marital status, or irrespective of whether you have the best marriage in the world or the worst marriage in the world, or you just want to be a single person, I recommend to my clients that they review their estate planning documents once a year. Now, I'm not going to pretend that I believe that my clients necessarily do that. The best trick I try to teach them is put your estate planning copies with your tax records, because you're going to look at your tax records once a year.
And you know you're going to have to complete those every year.
I know for myself, I put my estate planning documents right next to my tax record, my tax file for the year. So I remind myself to look, because when I have my own estate planning, I'm not a lawyer. I'm not wearing that lawyer hat. I'm wearing just a person with an estate plan. So certainly reviewing it periodically is a very smart idea, because these documents are revocable, amendable, modifiable. They're not permanent until you pass away. So you can change them at any time that there are significant changes in your preferences or in your life. And certainly, Sherry, what you mentioned about a divorce, that is obviously a very key event in someone's life where that should automatically trigger you to review your estate plan. So that, because you may have had your spouse or you may have had somebody else named, and when you have that type of life-changing event, that should trigger a review of all your estate planning documents. But certainly anything to do with power of attorney or health care, you may probably have named if you're married, you've named your spouse, and that may not be the person you want anymore.
Well, Steve, this has been very, very informative. I think it would be great if you could come back again and we could talk about estate planning and really death planning. So I want to thank you so much for coming today, and I want to thank all of you viewers for spending time with us. We sincerely appreciate it, and we thank you, and live each day. Life is so very, very precious, and we'll look forward to seeing you soon.
Thank you, Sherry.
Thank
Pleasure.
you. This program was made possible with the generous support of the Magnolia of Millbrae.
The Magnolia of Millbrae is a senior living community that provides a variety of services and amenities to its residents. For more information, call 650-697-7000 or visit their website at www.themagnolia.com. MCTV thanks them for their support.